What happened is the procedure changed. I mean, we had this in the manifesto, that is correct, but it was also one of the questions looked into by the Commission, which was set up on political and parliamentary reform. And the Commission included that as the proposals when they reported at the beginning of 2013. I mean, it has been, although the codes are based on the UK code, especially the parliamentary one, I think you'll find with the ministerial one, it needed a considerable amount of work to adapt it to Gibraltar, because there are things in the UK which simply don't exist here. For example, the concept of having parliamentary private secretaries or having special advisors, which they do in the UK. We don't have any of that here. So the code needed to be adapted, and I think it's gone through 8 or 9 drafts, if I'm not mistaken. So it's been quite an extensive piece of work, which the government has been conducting at the same time as obviously governing and doing other things.
Well, you've said that these codes are going to go before the Select Committee on Parliamentary Reform. Will that happen before the general election?
Well, we had the option of proceeding with the codes, which obviously could have happened because they could have been published and promulgated as being the codes which would apply. But the government did feel that because these were issues which were not only in a manifesto, which the actual Commission on Parliamentary and Political Reform itself had recommended, we felt it was important to go to the Select Committee, which has been set up, and which is looking precisely into all these issues, including the question of having a code of conduct for ministers and a code of conduct for members of parliament. So we felt it was a proper thing to do.
And will it happen before the general election?
Well, whether it'll be tabled at a meeting before the general election or not is something I can't answer. What I can say is that before the statement was issued at the end of last week, we supplied the codes to the 2 members of the opposition who sit on the Select Committee.
Okay, and how will these codes actually be enforced? Because, of course, they don't have the power of law. How will you implement them?
Well, the two are very differently. The Ministerial Code, for example, in the United Kingdom, is essentially administered by the Cabinet Secretary, and there is an office set up for property and ethics matters within the Cabinet Office in the UK that looks at the administration of the code over there. What we've done here is we've created a sort of parallel situation, but obviously on a much more reduced scale, and we're using the Chief Secretary to be the one who administers the code and the point of reference, for example, for advice or for determining in terms of registers of interest, in terms of gifts received by ministers. We'll use the Chief Secretary as a point of contact to provide that guidance. Now, in terms of the parliamentary code, what we've done is the Select Committee and Parliament itself really should be the ones who set up the mechanism. Obviously, we don't want anything as elaborate as in the United Kingdom, because in the UK, as you will remember, I'm sure, they had this scandal with allowances that many years ago, when members were claiming allowances for building moats and duck ponds and all sorts of things. We don't have allowances in Gibraltar, so obviously it shouldn't be that difficult to find a mechanism here.
Okay, and in terms of the ministerial code, as opposed to the one that is applicable to all MPs, it says that the Chief Minister will be the ultimate judge of the standards and behaviour that are expected of a minister and the consequences of a breach of those standards. What would happen, for example, in a hypothetical case that the allegation of the breach is by the Chief Minister of the day?
Well, it's a hypothetical situation which hasn't happened in the UK either. I mean, in the UK, those same powers are exercised by the Prime Minister. So people will make a complaint or submit a report to the Prime Minister, and he'll determine whether it's something which should be investigated or not. In this particular case, we've mirrored that here in the sense that it's the office, or it's the Chief Minister who would have the same power as the Prime Minister in the UK.
As you know, many people have complained about the level of the language and the tone used in Parliament in the exchanges between members of the government and the opposition. In fact, the Speaker himself has drawn attention to this. Will a code like this address that?
Well, the Parliament chamber itself and debates in Parliament are regulated by the standing orders and the rules of Parliament, which are a separate document which are already in existence. But certainly I think the code adds to it in the sense that it says, for example, that members should have the interests of Gibraltar first. It also says that in relation to their dealings, for example, and their private dealings, their private life, the financial interests should be entirely separate and should be above board in relation to the procedures of Parliament. But certainly the Parliament shouldn't be brought into disrepute is one of the other factors contained in the code. So although this is provided for in the standing orders and rules of Parliament, certainly there is extra or additional provision in the draft code.